Welcome to another special edition of Legal AF, the hot take everybody's wanted, backed by popular demand. Judge Barbara Jaffe retired. She served in the Manhattan Supreme Court, principal law clerk in the criminal division, and a judge presiding over criminal cases, just like Judge Merchan, the judge that's presiding over Donald Trump, and today found Donald Trump in criminal contempt for about 9 of his separate social media posts attacking witnesses, attacking and undermining the fair administration of the judicial system, which matters to judges and matters to Judge Merchan. Now, some people might be upset or concerned about how limited the powers of a judge appear to be when they're dealing with criminal contempt, short of putting somebody in jail. We'll talk about the fine system that's used, what you have to prove in order to obtain a criminal contempt order, which the Manhattan DA has now obtained. And I can't think of anybody better. As soon as I saw the order, I said, I got to get Judge Jaffe back with us to talk about this from her unique vantage point and perspective. So Barbara, here we go. So we got an order. The order found that Donald Trump is in criminal contempt, that the prosecutors have proven beyond a reasonable doubt, or whatever the standard is, that there is criminal contempt, and has now turned it over to the judge to sanction Donald Trump. And he did, to his limits. Also made some observations about witnesses and First Amendment rights of Donald Trump. I want to break it all down with you. Why don't you tell me what you saw from the perspective of you having been in the court system for as long as you have been?
I admired Judge Merchan's approach to this. First, I have to say that his written decision was very well crafted, very well written, and very clear. And I think that you don't have to be a lawyer to understand what he wrote about. He was methodical and well organized as well. He gave a little bit to the defendant in that he Exhibit 1, which was 2 statements by Michael Cohen, he found that the people did not sustain their burden of proving that those statements that the defendant's response to those statements were contemptuous. So he gave a little bit. He threw Donald Trump a bone, and I think that lends a lot of credibility to the other aspects of his decision. That doesn't mean he had to do that. He certainly didn't have to, but he did it because it was the right thing to do. The burden of proof on this is reasonable doubt, beyond a reasonable doubt, just like in any criminal trial. And that's because it's criminal contempt. There is civil contempt as well, and that has a lesser standard of proof. That's clear and convincing evidence, and the penalties aren't as great. Just remember, a very important part of this is that guilt of criminal contempt permits a jail term, not imprisonment in upstate, but a local jail term of up to 30 days. That's nothing to sneeze about. And I think that's why it requires beyond a reasonable doubt.
Let me ask you something, Barbara, Judge Jaffe, because we always like to make this a teachable moment for our audience who doesn't practice law or practice being a judge for a living. Did this start as a civil contempt proceeding, or have we now escalated this to criminal contempt, or did we skip right over civil contempt and go right to criminal because we're in a criminal setting? How did that work?
I really am not aware of any civil contempt because he violated a gag order, and I believe that would give rise. But I don't know. Do you know that? Is that
no? I think you're right. I think you're right. I think it's because the gag order of the judge, the first stop on the train was criminal contempt, whereas, let's say, in other settings, usually a civil setting, if you violate some order of the court, it would start as civil, then you'd be given an opportunity to fix it. And if that didn't work, we then go to criminal, and then criminal potentially to jail. Here you skip all those steps, right? It's like Monopoly. You go straight to potential jail because of the nature, as you said, the nature of the particular gag order. Talk to our audience about what toolbox a judge has as part of their inherent authority in New York law and under the and the different rules and statutes to punish for criminal contempt. Because you saw in the order, and we can put it up on the screen and I'll read it to you, Judge Merchan struggling with how to fashion his remedy, particularly if you go to the page 7 of the order, and we'll put it up on the screen, under punishment and order, you see the judge struggling. I'll read it to you under punishment and order. It says, however, the judiciary law, which is what empowers the judge to fashion this type of remedy, does not vest the court with authority to craft an appropriate punishment when a $1,000 fine will not achieve the intended purpose. While $1,000 may suffice in most instances to protect the dignity of the judicial system, to compel respect for its mandates, and to punish the offender for disobeying a court order, it unfortunately will not achieve the desired result in those instances where the contemnor, the person whose contumacious conduct is at issue, can easily afford such a fine, like Trump. In those circumstances, he said maybe even a $150,000 fine wouldn't be enough. But that he sort of laments here as a judge the limits to what he can use in his arsenal. There was a lot of speculation, for instance, Barbara, by other court watchers that like, well, he could do all sorts of things. He could set up a monitor over a social media program, or he could, and I'm not sure he could do any of that under the judiciary law. What do you think?
Oh, he definitely cannot. The two remedies are $1,000 per incident of contempt and up to 30 days in jail. That's it. And there's case law saying you can't do anything else. And I think that's reasonable because don't forget, it's not a trial. He's not, this is during the course of a trial. So you can't just layer punishment on punishment, in my view.
Yeah. Because he's already presumed innocent of the underlying charges, and it's not like the case that you were here giving commentary about the Judge Engoron civil fraud case, where the judge, after an evidentiary hearing and everything else, made certain findings at the end, and even during his interim relief, things like let's install a monitor and let's, that's an arsenal. Some people might be thinking, wow, the judge in a civil setting has more powers than a judge in a criminal setting. And yes, sounds like from Barbara, your perspective, right?
Absolutely. Absolutely.
So, and I know a lot of people.
30 days in jail. Yeah.
Yeah. To your point, civil judges don't get to put people in jail generally. Generally, I mean, there's some criminal contempt that could happen in a civil setting, but generally they don't. But that's the problem. The judges like you only have a giant hammer and nothing short of it. But answer the question for our audience. The judge had 9 examples of violation, including 6 that happened after he issued the expanded order, and some that happened between the expanded order and the time of setting the hearing on the 23rd of April. So in other words, a completely out of control Trump. Why do you think the judge only fined today, wagged his finger about, don't forget, this is now the second time he's told him, don't forget, I can jail you. Why didn't he jail him today?
I don't know what's in Judge Merchan's head. We can speculate that maybe, and I've heard this said not about Judge Merchan, but I heard it in the media, that maybe you don't want to give Mr. Trump what he wants. And he said, oh, sure, put me in jail. And you don't want to, do that for him. That could be one reason. It could be that he's trying his level best to be properly reasonable, to be very reasonable, and only to put him in jail when it becomes such a terrible thing, where Donald Trump does something even beyond just talking about people, depending what he says. As we know from the civil fraud trial, Donald Trump, utilizes a great deal of plausible deniability. That's something he uses a lot. And so you have to skate carefully when dealing with him because of this plausible deniability. And while we all know that even if it's plausible, it's not probable, you want to be careful. So maybe he's just waiting for the other shoe to drop and a big shoe to drop. That's my view.
Before we turn to what I thought was another thing that's getting underreported about the order, which is the judge basically calling out in his own way some of the quote unquote protected witnesses that are the subject of the gag order and telling them, and you and I can speculate aloud who we think that he's talking about. He's not going to allow those witnesses that demonstrate that they're not intimidated, they're not having their witness testimony affected by Donald Trump, who are instead being a little bit aggressive in social media and in interviews and don't seem to need the court's protection. He's not going to allow the gag order to gag Donald Trump while they get a free run and a free ride on Donald Trump. Particularly, it was in the paragraph talking about Stormy Daniels and Michael Cohen. Now, Michael Cohen, of course, is on our network, but to me, it was a not so veiled comment directed towards somebody like Michael Cohen, like, be careful what you say and do on social media, because I may ungag Donald Trump if you don't really demonstrate that you need his protection, the judge's protection. What did you make of that? And let me read it, and then I'll ask you to respond so people know what I'm talking about. Sometimes I paraphrase. I want to make sure. So there's this interesting thing that kind of got glossed over by people that have been reporting on this. Not Ben, but other people. So particularly, he says on page 6, Judge Merchan, that this is about the First Amendment right of Donald Trump that he's trying to balance. He says at the bottom of page 6, at the same time, this court is keenly aware of and protective of defendants, that's Trump's, First Amendment rights, particularly given his candidacy for the office of the President of the United States. It's critically important that his legitimate First Amendment expression not be curtailed. For that reason, the court exercised discretion when it crafted the expanded order, and it delayed issuing it until the eve of trial. The order is narrowly tailored to prevent risk to the fair administration of justice, and it clearly and unambiguously identifies the limited way in which the defendant's speech is restricted. And here comes the kicker. It is of the utmost importance to this court that the expanded order not be used as a sword instead of a shield by potential witnesses. Consideration of such usage will be weighed by the court when ruling on willfulness. In other words, if I put Donald Trump in jail for the next one. In fact, the court goes on to say, the court may very well consider the propriety of continuing the limitation on extrajudicial speech as it relates to certain individuals. As this court observed, it remains this court's fundamental responsibility to protect the integrity of the criminal process. The underlying purpose of the restriction on extrajudicial statements, meaning statements outside the courtroom, is to protect the integrity. However, over to page 7, if a protected party turns the underlying purpose on its head, that means a witness, i.e. Stormy Daniels, Michael Cohen, and others, it becomes apparent that the protected party likely does not need to be protected by the expanded order. From a judge perspective, what is Merchan signaling?
He's signaling his utmost fairness and reliance on the First Amendment and all those wonderful, excuse the expression, liberal values of broad-mindedness and giving people a break and trying to be understanding of somebody. However, one thing I did notice in this decision is that the aspect of intent, willfulness has to be proven. And he didn't address that except for the posts on the social media. I don't know if that ties in with what you're mentioning, but I think that Judge Merchan was very level-headed about this and very thoughtful.
And he found willfulness. Now, let me ask you the question that's burning a hole in everybody's pocket here in our audience. One more post, or he doesn't take down, because he was required to take down certain posts from his Truth Social and from his campaign. He misses that deadline, violates that deadline, reposts again in violation, right? Because Donald Trump has a habit, like a toddler who hasn't learned that a stove is hot. He first puts his hand on it Then he puts his face on it. If he violates it again, another post or two that violates the Hispanic gag order, yes or no? If you were Mershon, would you put him in jail for some amount of time?
I would. I certainly would. And again, he's been so incremental about it. He can continue to be incremental. He doesn't have to put him in the cooler for 30 days, but he can certainly put him in for an afternoon, a day, a weekend, and little by little till they get up to 30 days. Because there's no question in my mind that this is all intentional behavior. The willfulness that was with respect to a different aspect of the decision. But I think that everything must be incremental with Donald Trump. And that I think your analogy about a child putting their face on the stove is true. He's a child who is testing the parent. He tested Judge Engoron throughout the civil fraud trial as well. It's juvenile behavior.
Yeah, exactly. But you heard it here, folks. Judge Barbara Jaffe would put Donald Trump in jail. Let me just leave it on this. You like that? You like that soundbite, Barbara? That's going to be the soundbite. It's true. It's true. It's okay.
I'll get
but you'll be fine. Well, you have the protection of the Midas Mighty and the legal AFers. In terms of the jail, and I did a hot take about what jail looks like, the shape of jail for Donald Trump. And that the Secret Service, we know, based on reporting, is already in conversations with the court system and those that run the jail about what that would look like. So it's not Rikers Island, right? Where is the jail?
MCC next to 100 Center Street. Could be, if it's just an afternoon, it would be a holding cell at 100
in the courthouse.
Center Street. Yeah, or the Metropolitan Correctional Facility. I think there was one right next to, just north of 100 Center Street.
So he's in the trial, just to orient everybody, the trial is at 100 Center Street. You can see how much time I spent there. 100 Center Street. So the jail could be in any of those locations that you just identified, right?
I don't think they'd send him to Rikers, even though anybody sentenced to a misdemeanor serves their sentence at Rikers. And that means from, 10 days to a year, less than a year, will be at Rikers Island. And I don't think they're going to want to send him to Rikers, even if on the off chance that he gets 30 days in the cooler. He's not going to go to Rikers because it's such a pain to get him from Rikers to court every day.
Right.
They don't want that logistical nightmare. I can guarantee you.
New Yorkers don't want to make it easy on themselves. We're going to put him through the process of Rikers Island. We're going to put him next door. And if they put him next door, not only is the judge going to be sending Trump to jail, he's going to be sending the Secret Service detail to jail, because they're going to have to go and guard him, right, with protective measures inside the jail.
That's correct. So we said, but can I go back to one little point from before about Michael Cohen? I heard somewhere, maybe it was on MeidasTouch, I don't know, that he decided he's not talking anymore. He's not going to use anything as a sword. Michael Cohen, in conjunction with his counsel, who we know, is made the decision that he's going to stop talking, and I guess stop posting and stop TikToking and stop social mediaing and whatever he was doing. So, right. But if I'm Michael Cohen's lawyer, Stormy Daniels' lawyer, anybody else that's a witness, I think it's really them. The judge spilt some ink there and took some time on his computer to tell people and tell Donald Trump, look, I'm looking out for you, man, in my own way. You may not agree with that. This is my artist rendering of Judge Mershon. I'm balancing your First Amendment rights. I'm not going to allow you to have both hands tied behind your back or yourself gagged while others attack you. I think that is unfair. And I'm warning everybody going forward, and I'll cite back to my order now, that if they go after you, I'm going to ungag you. And again, that's back to your sober, measured balancing. Reasonable, right? And fair. And a little phrase that I believe I coined many years ago is that a judge's best friend is the law, is our statutes, and all the guidance that we have. Also, burdens of proof are a judge's best friend because they guide us in how to render decisions. So when the burden of proof here is proof beyond a reasonable doubt, the legislature has told us, has transmitted to judges that we do not want you to sustain a guilty verdict on anything less than guilt beyond a reasonable doubt, because criminal sanctions are so serious, the punishments are so severe that we don't want that in this society. And those are fine, again, excuse the expression, liberal values that are good for human beings and animals, in my view.
Yeah, you never have to apologize for liberal values on this network. Retired Judge Barbara Jaffe, formerly of the New York State Supreme Court in New York, talking about things that matter, like what's happening in the criminal trial of Donald Trump. It's always a pleasure. I'm hoping to make you a regular contributor here. You have a voice that matters, and you occupy a position of one as a former judge who's also a legal commentator and contributor to the network. And I thank you for being with us again.
Thank you for having me. It's a real pleasure.
Yeah. Shout out to the Meidas Mighty and the Legal AFers.
Hello, Meidas Mighty and the Legal AFers.
Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.